So if you can please select the blue button on your screen to accept recording, and we'll go ahead and get started. My name is Sandra Vidrio here with the Fresno Area Hispanic Foundation, and we are glad to have each one of you join us for today's webinar. I want to go ahead and move forward with the presentation for today. We are joined by Bill Kell, who is the director at the New Business Community Law Clinic. And we have a pleasure of being connected, having this great partnership to bring you this monthly, every third Friday webinar. So thank you so much. And with that, just a reminder by now, most of us that are logged into Zoom are familiar with how Zoom works. So during the course of the presentation, simply go ahead and leave your questions in the chat box. And of course, at the end, we will have an interactive presentation, interaction with each one of you and our presenter for today. So these are just ways on how to use the chat box. And I do have, we are going to be providing interpretations. So with that, I'm going to stop sharing the screen just for a few seconds here while I provide access to our interpreter. So we are joined by the team at Linguistica. So thank you so much, Linguistica team, for joining us for today's interpretation. So, si se están uniendo en español, simplemente seleccionen la opción de español para poder participar en la presentación de hoy. So here is a vivid example on how to go and do so. So seleccione la opción de More, Language Interpretation, y después seleccione el idioma en que quiere escuchar la presentación. So select More Language Interpretation, and you can select whether you want to listen in English or listen in Spanish. So with that, let's go ahead and move on to the second slide here. So we would like to say thank you to all of the following companies for their support these last couple of years with the foundation, really being able to help us move forward with providing our services, not just here in the Fresno area and the Central Valley, but throughout California and also throughout the United States and even Mexico now with our program, our import-export program and our Latinapreneur program. So our presence is worldwide, and it could not be possible without the support of Bank of America, Comcast, Bank of the West, Bank of the Sierra, Chevron, Donna G Sales, JP Morgan Chase and Company, Union Bank, and Wells Fargo. Thank you so much for your support towards our organization. And this is the agenda for today. So my name is Sandra Vidrio, as mentioned at the beginning of the presentation. We are joined by Bill Kell, who is the clinic director at the New Business Community Law Clinic at UC Berkeley. And we will complete the presentation with a Q&A session with all participants. The Fresno Area Hispanic Foundation, we are an organization that has been here in the community since 2004, and we provide a variety of programs and services, not just for startup businesses, but also for existing business owners. And we've been working very closely with a lot of you in regards to COVID-19 relief grant opportunities, as well as microloan opportunities to reopen the doors to your business. So I just wanted to share with you who the team is and the work that we're here to support you with. So providing you with the weekly webinars, providing you with one-on-one technical assistance, which technically is one-on-one business support, and of course, connecting you with other capital opportunities to continue expanding and growing your business. Our office is at 1444 Fulton Street, and you can contact us anytime at 559-222-8705. And you can also visit our social media platforms to catch up on what our day-to-day that we have going on, and also our YouTube account to be able to see past webinar recordings. And if you are a business owner that is joining today's call and that your business has been opened prior to June 1st, 2019, and if you have not had an opportunity to apply for the California Small Business COVID-19 Relief Grant, this is your opportunity to do so. I believe this is the final round for this program. So if you or someone that you know of has not been able to apply for this grant opportunity, please contact our office, and we'll be happy to guide you through the process and share with you all of the details. And with that being said, if anyone has any questions, you can go ahead and leave them in the chat, and I'll make sure to get to them. And I also want to share a little bit about the Womanpreneur program, which is a program that's going to be starting on September 30. This is our English cohort. And we also have a Spanish cohort starting September 28. So this is a program, it's an 8-class virtual program where we teach women how to promote their business online, teaching them different subtopics related to marketing. And so after after the cohort, for the last 3 rounds that have taken place, we provide a business pitch grant opportunity. So there's grant programs involved for participants that go through the program. So to find out more information, feel free to contact me. I'll leave my information on the chat box. And you can also visit our website at fresnoahf.org. And with that, we will jump right into the presentation for today. And those that RSVP previously, I did send over the presentation slides in advance. That way you can have a copy for those. But with that, I will go ahead and pass on the mic to Bill to share your screen and get us started with today's presentation.
Oh, that's great. Thanks, Sandra, so much. And everybody, do take advantage of Fresno Area Hispanic Foundation's great services and the help with that grant program with the state. They are here to really help your business, and we're really proud to be part of them. So, Sandra, I will say, I actually worked on the slide deck a little bit more last night, added a few things, so I'll send you an updated version of it that you can share with everyone. After this program here today. Well, thank you folks for joining in here. Make our legal services available for free to people, but at the same time, we help train the next generation of transactional lawyers. So Lena's one of our stellar students, and we'll be around for the question and answer period too. So. All right, well, let's get to some interesting stuff around marketing. Okay, here we go. Let's get the PowerPoint up here. Go, slideshow, beginning. And I think my internet has been pretty good lately, but if there's ever a point where like I drop out or something like that, yeah, just hang around. I should be back in a moment or two. Sorry about that. These things happen. So as we said, today we're going to be focusing on marketing and the legal aspects of marketing. I'm only going to flag a couple of them. I mean, there's all kinds of legal issues that come up with when you're trying to get connected with customers and stuff. But the main thing I wanted to flag, well, before we do that, of course, little admonishment always, which is that this is a workshop that is, an overview of general legal information and not a substitute for working, individually with a lawyer. Which we'd love to do with you if you can't afford an attorney. And at the end of this presentation, we'll have a link that you can use to sign up for office hours. We have office hours usually around the 3rd Friday here. So we have one session we're going to do after the session today. But we regularly have them Monday and Wednesdays, 11 to 2 p.m. And so that would be, something you just go to our website, which you get the link at the end of this training, and then you sign up for a future session on Eventbrite. It's a 45-minute free talk with a lawyer and our great students. So, okay, well, so here's what I'm saying to you is that there's all kinds of legal stuff we might cover in this area, but I've picked 4 for today just to not overwhelm you guys a little bit. So first, probably the most obvious one you would be thinking about would be, okay, well, what if I marketed something that just wasn't accurate? How much do I have to worry about people checking me or the FTC checking me on stuff that I'm putting out there in terms of advertising? I think that's sort of the sweetest spot that we will be covering today, and showing you some really sort of amazing things that people have tried to do on the web and gotten caught for. Then we're also going to be focusing on, sometimes marketing will involve like competitions, like a sweepstakes or something like that. So we want to make sure you knew the law in that area there. And then next would be copyright. Okay, well, you're making your website beautiful, you're putting up pictures, you're letting maybe your users post pictures and content and stuff like that. Yeah, you should know that there are copyright laws that apply to any kind of content that is put on the web, and of course in written materials as well. So we just want you to know the rules about that. And finally, your interface with the customer on your website, this sort of contract that you've set up with them that really has two parts to it. There's this terms of use, which essentially gives the rules for the user's participation in your website. And then there's privacy policies. This deals with the way that you are handling the information you get from users. And that's a highly regulated area, becoming more and more highly regulated these days. So again, we just wanted you to know the rules related to that. And then of course, at the end, we'll have some questions and answers. All right, well, let's start out with consumer law and advertising. Again, this is the sort of what is expected of advertising in terms of quality and truth and things like that. Okay, well, you should know that advertising, it's just one of your many marketing materials, activities that you might do, but it is significantly regulated by the feds and states, and subject to potential consumer lawsuits if people feel like they've been defrauded in some fashion. I was shocked when I saw this. Actually, my colleague Desiree LaFleur, who's one of our, shared this, and she had here, an estimate that there was 5,000 ads every single day that the average person sees. If you include things like, the ads on the sides of bottles or car logos or things like that. Well, I decided I would check and see if that's been updated. It has been updated. It is now 6,000 to 10,000 ads a day, if you can believe that. So with that much, being thrown around out there, assertions, promises, things like that, not surprising that's going to be a highly regulated area there. Okay. All right. So imagine this. We're going to start out with one of those sort of poster children situations of consumer marketing here. I'm going to show you this video here real quick. Let me step off of the share here, and then I'm going to start another one. Okay. I need to. Sandra, can you put me back up as host here? I thought it looks like I'm okay. Now I'm good. I'm good. Okay, thank you. All right, you ready to go here? Let's share the sound and let's optimize it for video. Okay, here you go, guys. Your next great, amazing vacation. Are you ready for this?
The actual experience exceeds all expectations and is something that's hard to put into words. All these things that may seem big and impossible are not. It gives people that type of energy, that type of power.
Okay, well, there's 40 more seconds of that, but you can guess where this is going. I love the pig there. That was really cute. Okay, well, this thing called the Fire Festival. Wow, that just sounds so great, right? All right, well, this is what actually happened if you decided to go to the Fire Festival. Are you ready for this? This is what the concierge desk looked like. This is the place where apparently you sleep on one of these sort of thrown away mattresses here. I mean, they put a model on there just to try to dress it up a little bit, I guess. And here was the dining experience that you had there. You ready for that? Yeah. So you immediately see there's a potential problem here. And there was a lot of lawsuits related to this. 2 Fire Festival guests got $5 million in damages after suing the co-founders here. People had gotten, VIP packages for huge amounts of money. Tickets range from $450 to $100,000. So yeah, just if the government doesn't regulate something like this, you should just know that consumers can get really upset about some things that happen that they did not anticipate when they were promised certain things. So they probably should have spent a little less on the video, let's say. So let's go back to the, oh shoot, did I do that again? Just a sec. Get back again, get back to my PowerPoint. Oh, I already did this one. Okay, sorry guys. Somehow I popped off of the slide I was on. Okay, keep going, keep going. Okay, here we go. Start that one again. Sorry. Here we go. Now, so you might wonder, okay, well, who regulates advertising like this? If the consumers didn't come forth with major lawsuits in this situation here, who takes care of something like this? Well, you should know that this has been around for a while. These things in 1872. This is why you hear things like, for example, Donald Trump has been accused of mail fraud. Okay, mail fraud. Why is it mail fraud? I mean, did he use the mail to do stuff? Well, that's the thing. Back in 1872, this is the only way people communicated with each other was by courier or mail or something like that. And so they were doing things at this point in the late 1800s. Scammers were putting like ads in local papers for this kind of fraudulent stuff that maybe didn't have so many zeros associated with the Fire Festival, but same kind of thing, just promising stuff, and then people would show up or people would buy it, and it was just totally nothing. And so Congress set out these federal mail fraud laws that have now been adapted to work with things on the internet, for example. So the following federal agencies primarily regulate advertising. You should know the FTC, the Trade Commission, is primarily responsible for regulating advertising, while the Food and Drug Administration specifically focuses on food and drug related advertising, all the claims and things that people are making with that. But then you should also know that states have their own consumer protection laws that will regulate ads in their state. So it may be that a particular state, well, like California, is going to have even tougher standards than the feds will, okay? But we're going to cover what is expected in just a minute. Okay, so probably a good place to just start is to take the FTC's Truth in Advertising rules, which you can find at this link up here. All right, so under the Federal Trade Commission Act, generally the guidelines are, of course, advertising needs to be truthful, non-deceptive. Advertisers need evidence to back up claims that they might make about their products. Advertisements cannot be unfair. We will explain in a minute what that might be, what that might involve. Actually, unfairness is particularly found when certain information is given, but important, relevant information is left out. So that's just seen as, well, yes, certain information. The information you got might be truthful, but the context for it that shows something very important has been left out. And then, there's certain ads for certain products that might be regulated. So for example, credit, extending credit, you have to, be very careful in the way you describe the terms and things like that. So these are things to pay attention to sort of as the sort of general rules around advertising. Let's keep going on a few of these here. What makes advertising deceptive? Well, here you go. It's deceptive if it contains a statement or omits information that is likely to mislead customers who would be acting reasonably. Information that's material, meaning a person would buy, it would be important to know this information and to have truthful information to help a consumer make the decision to buy or use that product there, okay? What's unfair? Well, it's where maybe it is likely to cause some injury, but it's not, fully disclosed to the consumer, so they'll know whether to take on this risk of some sort. And of course, here there might even be a balancing kind of situation here, that the advertisement may tell you about something that is an opportunity, but the risks involved in it are so great that just, consumers are put really more at risk buy this thing than, you know, the benefit of informing the consumers about it, you see. Okay, a couple other things. FTC always looks at the ad from the point of view of the reasonable consumer, you know, just sort of a standard, what would a consumer think here? So here's one. There's express and implied claims. So if you have a mouthwash and it says ABC mouthwash prevents colds, okay, well, that's an express claim that it will prevent colds. But what if it says it will kill the germs that cause colds? Well, that implies that it's also going to prevent colds, you see. And so the advertiser has to have proof before they put this out that both express and implied claims are true. Okay. Finally, the claim, you would look at the claim whether it was material that is important to the decision. Again, if the claim is based on, the claim is, or the information given is related to how it performs, is it safe, what the price is it going to be effective for what I'm buying it for? Any of those things are just presumed to be important to the consumer to make a decision whether to use this or not. And again, advertisers can't just be called on this stuff and then they go, oh, give me a month and I'll get some backup data. No, you know, if they're confronted on this by the feds, by the FTC, they better have this immediately, and it's supposed to be there before the ad runs. All right. So if you have some questions about the false advertising rules, just that sort of thing, yeah, feel free to jump those into the chat and we'll try and address them directly. But this is more of an overview of what the FTC is going to be expecting here. Okay, so what kinds of claims does the FTC target? Certainly about health and safety stuff, you know, ABC sunscreen reduces the risk of skin cancer, or water filters. These water filters will, you know, make the water safe to drink or something like that. Okay. Ads that consumers would have trouble evaluating themselves. So for example, these appliances will reduce your energy costs by 25%. Well, you'd have to sort of pull all of your utilities and compare it, you know, the bills and stuff. That might be a little hard for people to do. Here's another one. ABC gasoline reduces engine wear. You know, unless you're a mechanic, you have no idea how to look into something like that. So in contrast, you can probably guess that the FTC cares less about things that consumers can judge for themselves. So for example, just that this tastes great, you know, or that, what is it? The French, oh, no, Tony the Tiger, you know, the Frosted Flakes are great. Well, they're not going to pay that much attention to that because normally consumers can judge for themselves whether they're great or not. All right. Let's see. Next, unfair competition, deceptive ads. So these would be things like, you know, if there are disclaimers that you want to say, or like here's a good example. The shoes were $100. And then somebody just stuck up this extra one, which was, oh, well, it used to be $200. Well, it better used to be $200 and not just somebody throwing that sign up there, because truthfulness also applies to ads that seem to imply that there is a sale when there really isn't a sale. All right. Here's one. Love J-Lo here. Love, you know, that we got her here. Is this an ad? This is like her I think this is in her Instagram page. Isn't that right? I mean, look at that. Let's take a look at this here. Okay, well, looks like she's just having a good time there, right? I mean, you always sort of hang, I mean, I know I hang around my house in beautiful clothing with alcohol displayed, and, you know, to all my couple fans on Instagram, I mean, I'm not even on Instagram. Anyway, so I guess I'm trying to say is, yes, this is actually an ad, okay? Even though it's also an Instagram page. And so if she's saying stuff like, oh, well, you know, maybe, you know, we know what happens with alcohol, but if she has like, oh, you know, I've got this remedy for, you know, skin, you know, it'll make your skin look so great, something like this. And it's sitting right next to her. And well, actually, I got one that's sort of like that. Here you go. Here's Kim Kardashian here, okay? When you're doing endorsements like this, first it's got to be the honest opinion of the endorser. Okay, and you can't use like Kim Kardashian to say, oh, you know, this stuff here, what is this here? Change, what is it? Have you heard about this? You guys know, oh, my morning sickness. Okay, oh, morning sickness. She's had morning sickness. Okay, well, she can't make claims about this product that the company itself can't make. Just because it seems like she's just talking sort of conversationally here. Oh, I've studied, it's been studied and there's no increased risk to the baby. Well, where did that come from? The company is supposed to be making those kinds of claims. If somehow they weren't making the claims, but using their spokesperson to do so, Kim Kardashian, that's a real problem, potentially. I guess another thing that the FTC is going to look at is, well, look, you're just doing this out of the goodness of your heart, right, Kim? Yeah, right? No, she's probably a paid spokesperson, collegious, whatever it's called. And so you need to say that in your ad. You need to say, I am, let's see, what does it say here? This sort of says it. I'm partnering with Duquesne USA. Apparently they produce this drug. I'm partnering with them. Again, I think that's a little misleading because obviously they're paying her to do this. So in any ads, you generally have to say, you know, this person is a paid endorser, or, you know, if it is just somebody on the street and you just, you know, interviewed a customer, you know, you can reveal that too. You can say this is just a customer picked at random or something like that. Okay. All right. Well, that's, I think, as much as I wanted to say about advertising. The next thing, oh, no, I forgot, there's sanctions. Okay, here we go. If the FTC determines there's misleading advertising, there are sanctions. Okay, there's actually been some pretty big sanctions here. There could be cease and desist orders that come out of the FTC that would just say, stop that advertising right now, pull it from all mediums. There could be sanctions of money. There could be corrective advertising that's required. So you should remember, I don't know if you guys are old enough to remember this ocean spray cranberry guys that would stand out in this field of cranberries and talk about how great and how much cranberry juice was in their cranberry juice. And it actually wasn't true. There really wasn't that much cranberry juice in it that they were claiming. And there was a whole bunch of sugar in it too that they were claiming wasn't in there. And so they actually got hit with, they had to pay like 25% of its advertising budget just on corrected gas, which I think, you know, I don't know how they survived finally, you know, because there was a big consumer fallout with people just sort of going, look, this is just sugar water, really, is what they're doing. So yeah, the FTC can get involved and get you some sanctions and some cease and desist and order you to correct some things. Okay, well, here, these shape up shoes. I'm sorry that we're going after the Kardashians a little here, but these are supposed to be shoes that would help you tone up, obviously, so you would look exactly like Kim and who's that, Kris Jenner. Well, actually, they got slapped with a total of $40 million for people who bought these body toning shoes, which didn't actually work. So, you know, it's real out there, these kinds of penalties. And then there's one other kind of thing that you might think of doing. Oh yeah, the old Coke and Pepsi wars and all of that. This, you still have to be kind of careful in claiming superiority over a competitor's product, either expressly or these things, you know, it certainly gives the other who was in the, you know, the inferior position a chance to potentially file a lawsuit against you for the way you misleadingly created the test or something like this. This could be civil suit or FTC intervention. You just have to be really careful in the way that you assess a competitor's disadvantages versus your own. Okay, well, that was the main thing I want to say about advertising. Let's talk a little bit about promotions using competitions, okay? Just so you know, there are contests. These are regulated by the state mostly. State of California has a lot of contest laws that are out there. The idea is that in a contest, there's some way that the winner is chosen because they did something better than the others, rather than like a lottery where you're just picked from a group of people. Just know that a contest is something that you could say that they have to make a purchase in order to participate in the contest. Okay, so if you participated, you're writing an essay about how great this rice pudding is. Okay, well, you got to buy some rice pudding, and then say what the rice pudding means to you, and then they'll have to have on file before the contest begins what are some of the standards for determining who did better than somebody else. They can't just make it up as they go along. Okay, so sweepstakes are a little different. Okay, so there's some luck of the draw here. Okay, if you ask somebody to do something in order to get in the pool, that's okay, but watch it, because, well, here you go. Let me give an example. All of the people, let me just try to remember an example here, would be something like you set up a sweepstakes, and it's like here you go. It's like a scavenger hunt, and it says, we're going to take all of the people who found all these items that we put around the East Bay or something like that, and whoever was able to do that, we'll put them in the pool, and then we'll select from there. Well, the thing is, if you ask them to do too much, if in the example I gave you, they're going to be driving around, potentially exposing themselves to danger if it's in a, the item was put, on some, end of a pier or something, you have to lean out and get it or something. Anyway, the main thing I'm trying to say is that sweepstakes that ask too much of you at the beginning to get into the pool could be seen as requiring certain actions of you that you should really be compensated for if you didn't get picked, you see. Even though in sweepstakes there's the prize and the element of chance, it's this sort of asking you to do all of this stuff may in some ways be seen as creating a contract with you that in some ways you're very likely to win if you do these sorts of things. So the wording around sweepstakes has to be really careful too. Now remember, lotteries are just games of luck where entrants pay to play. Lotteries themselves are highly regulated, but this one does actually require consideration, meaning you pay for a ticket. Yeah, my brother used to always say, the chances of winning the lottery are just as good whether you play or not. So the reason that people are cynical about that is supposed to be addressed by the fact that lotteries are highly regulated, and people aren't supposed to be distrusting like that. But that's the way those go. So just know that with each of, if you set them up as kind of a promotional campaign, these are going to have some regulations in it. You probably want to talk with a lawyer about. Okay. All right, now let's get into copyrighted content. Okay, here you go, copyright. Remember that little symbol there? By the way, interesting point. Many people wonder, okay, well, how do I protect? Oh, looks like my connection's a little unstable here, guys. Okay, hopefully it's going to go past. Anyway, well, this is a little bit of a mistaken idea. Is well, if I want to protect something with copyright, I just have to put this little symbol on it, right? No, that's actually not true. Let's just tell you a little bit about copyright to get you started, okay? Copyright is supposed to, these are laws, your federal copyright laws, it's actually in the Constitution of the US, protects original works of authorship. So that means like writing, it could be drawing, movies, software, advertisements itself, because it's usually drawings and writings and pictures and stuff. So it's supposed to protect these things, okay? The thing it does not protect is just the idea behind it. So here we go. I've been thinking, no, I want to write this novel about lovers whose families are warring and they don't, they come together and they want to, get together, but their families prevent them. Gee, doesn't that sound like Shakespeare? like Romeo and Juliet? Yeah, well, that's why a lot of people can write these kinds of things, because the idea of the star-crossed lovers is something that is not protectable. Once you put it down, you know, if I started using, you know, oh, you know, 'tis a rose that, you know, I start using the Shakespearean language for Romeo and Juliet, yeah, right there, that's protected because it's down in a written, changeable form. And so the Shakespeare Society or whoever owns it or something are going to be able to come after me for that. Now, there is a narrow exception. It's called the fair use doctrine, which we'll get into in a few minutes. But I'll just give you one example of that right now. See all those pictures I used and that video from YouTube that I used earlier? That's something you might say, well, wait a minute, did you just violate those people's copyrights? Well, I'm using it for educational use. I'm trying to inform people, give them, you know, ideas about the law, help them learn about the law and stuff like that. I'm not getting paid for this. It's not a commercial venture. That kind of educational, limited educational use is okay under fair use doctrine. Okay, but we're going to come back to that in a minute. All right, so here's what a copyright gives the owner of the works to do, or that they could do. They can reproduce it, they can distribute it. If it's like this, Alvin Ailey's great dance production there, you can perform it or display it. It gives you the exclusive right to do these things here. And so how do you get it? Well, here's the thing, production is automatic. It doesn't matter whether you have the little C there on the outside of it, you know, putting next to it. It's automatic. Once you fix the idea that you have in a tangible medium of expression, that just means writing it down, or if it's code, you put it in, you know, code in your computer. A picture, you take the picture and it's in digital form. You know, once it's in this form that can actually be transferred or used or something like that, that's when you get the protection right there, right at that moment, okay? Now, if you wanted to sue somebody to enforce your trademark, excuse me, to enforce your copyright, you know, somebody took your picture that you shared with them and put it up on their website as though it was theirs, okay? Well, that would be what's called infringing on your copyright there. If you want to sue somebody to stop it or get some damages from it, you do have to register with the federal government under, you know, here's the website to go to. It's actually fairly easy. You know, you pay a little bit of money, you upload it to the site. It's fairly simple how to do it, very lay friendly. And then the benefit there is once you have it uploaded, once you've registered this copyright, then the presumption is that the world is on notice about your copyrighted material here. And so if somebody uses it, then you can get what's called statutory damages, which is a set amount of money. I believe it's $30,000, somewhere in between $10,000 and $30,000 if somebody uses it the first time, okay? And so what you probably want to do, if somebody did do that, take your picture that you took, claims it as their own, puts it up on their website. First thing you would do is send probably a cease and desist letter. And, you know, if it's not a big deal to you, you know, you just want them to take it down, then a cease and desist letter would say, look, you know, that's my copyrighted picture. You don't have the right to use this. You didn't get a license from me. I didn't give it to you. You need to take that down or you're going to be facing some major damages. Yeah. All right. Now, if you hadn't registered your copyright first, that's where you wouldn't be able to say, but you're going to get 30,000 in damages. No, because you didn't register it. You don't get the statutory damages until you register it. You would just say in that situation the same thing up to the point of damages. You'd say, cease and desist, that's mine, take it down, or I'm going to take further legal action. Okay. All right, so protection begins the second you create it, you put it in the tangible form. There is actually this way of calculating sort of how long the protection lasts. It's your life, the person who put it down into tangible form, plus 70 years. If it was let's say you were an employee of a company, okay, then it would be 95 years from the date of publication that the employer puts it out there, or 120 years from the year of the creation of it, whichever occurs first there. And you should just know there's international treaties that recognize copyrights so that people aren't infringing them around the globe there. Okay. So what does this mean for you? Oh, well, here's this fair use doctrine. Let me mention this for you. Okay, so if you have copyrighted work of some sort, you can use it for some of these limited purposes here. Okay, so just the fact, here you go. Remember that Fire Festival video and all those pictures there? The newspaper that broke this, or CNN that broke this here, they can use those pictures just because they're reporting on, what happened in the world. Okay, to a limited extent, they could do that. All right. Teaching, as I said, is another. Research would be another. How many ads have done this or that, and so you may be able to present at your research institution. Oh, look at all the ads here, and this is, you'd have all that copyrighted stuff, but you're using it to explain your research. You see. Now there's some transformative things you can do, like let's say you do a commentary or a parody. By the way, one of my favorite parodies when I was growing up was, it was called Board of the Rings. And it was the Harvard Lampoon doing a whole book focused on the Fellowship of the Ring and the Lord of the Rings trilogy. It had, instead of Gandalf, was Good Gulf, and Frodo was Fredo, and the Riders of Roytan instead of the Riders of Rohan. Anyway, so you can see it was a parody. It wasn't intended to be a substitute for the Lord of the Rings. And, actually, the Lord of the Rings tried to sue it first, and, successfully, it was found to be a parody. But here's the main thing about fair use, okay? You will only know whether it works after you've raised it as a defense in a lawsuit, okay? You can't just sort of say, well, let's put it this way. If you started, let's say going back to the Board of the Rings book I was just talking about, Tolkien Society came and filed suit against Harvard Lampoon, said that is like our book, that's our copyrighted material. And that's where the Harvard Lampoon would come back and say, no, we're not going to cease and desist because that's fair use. Okay, well, it's not like then at that point, the Tolkien Society said, oh, dang, yeah, I guess it is fair use. No, they went on, and a court had to determine whether this was a fair use or not, which it did. Okay, so I guess what I'm saying to you is, be careful if you think something is fair use. You'll only know for sure if you get in a lawsuit. And again, fair use is generally not available for commercial use of copyrighted material. So I guess what I would say is this would be different. What I'm doing today to you with showing you copyrighted stuff would be different if I was charging for this workshop, you see. Okay. All right, well, let's cover a couple other things. So what does this mean for you in terms of putting stuff out there in your advertising or on your website? This thing called the Digital Millennium Copyright Act, or the DMCA. And here, what I did was I reprinted sort of how Instagram explains it to you, okay? As you can see, Instagram is committed to helping people protect their intellectual rights, okay? We do not allow the posting of content that violates someone else's intellectual property rights, including copyright and trademark. And as you see here, look, it's just awesome stuff from my own presentation here. It's explaining what copyright is, but what you need to have if you are posting stuff or letting people post stuff like users on Instagram, you need this thing called a takedown policy, okay? So let me flag for you what the Digital Millennium Copyright Act does, okay? There's two parts to it, okay? First is this anti-circumvention part, which essentially focuses on businesses that well, this would be like what Pandora was, or wait a minute, what was the precursor to Pandora that got sued out of existence? I can't remember what it was called, but it was just somebody, it was called, maybe somebody remember, put it in the chat if you remember. It was people just taking songs that they had in their collection and uploading them into some kind of, site where people could get access to, copyrighted songs for free. Yeah, well, they got struck down pretty fast by the DMCA, and that's the anti-circumvention portion of DMCA. Is they say basically companies can't set up these kind of, how would I say it, robots or black boxes or something that will just, take a whole bunch of copyrighted material and then just spit it out and violate everybody's rights. So that's one part of it. The other part is this safe harbor provision, and that's what Instagram is doing here. What they're essentially saying is, we will let you post stuff and all that, But if we find out that there's stuff that you put up, claimed ownership of, and it wasn't yours, then we are responsible for taking it down. That's what's called the safe harbor provision. That means that as long as they respond to consumer requests for, policing, infringing action, then they themselves are not going to be held liable. It's just going to be the third party that would be liable if they kept doing it, you see. Okay, so again, if somebody uses your copyrighted material, if they did it on the web, then you could do this DMCA takedown thing, usually on the terms of use of Instagram or one of these other posting platforms. It'll say, if you have, reason to believe something's infringing, let us know, we'll investigate it and take it down, okay? And so comparably, if you're doing the same thing, letting people post stuff to your website, that's where you need this kind of takedown policy. Okay. All right, well, let's now talk about those website terms of use and privacy policy. Okay, well, terms of use, what are we talking about? We're talking about those annoying things that you see whenever you go on a website that say, please click here to tell us that you have accepted our terms of use. Well, that's one way you accept terms of use, is clicking, saying you agree to them. But it's also, as long as they prominently display it on their website, not just hidden at the bottom in teeny little language, but if it says, here's our terms of use, usually at the top, it'll say something like about us. So it talks about the founding team or something like that. And then it'll say terms of use or privacy policy up, right up there with the key information you need to know. Okay, so we have some recommended terms for the terms of use. Not all of these address this copyright situation, but while we were on the topic of terms of use, we thought we'd give you some good pointers on it. And by the way, we do have some sample terms of use. So if you want to get a copy of a sample of terms of use or privacy policy, just put that in the chat in your email and we can get that to you there, okay? So with terms of use, recommended terms, okay, well, what we say is that terms of use need to reflect your functionality of your website, okay? So as we said, if people are posting content, then you're gonna need that takedown policy there, okay? Here's some other tips for you that don't really relate to copyright infringement, but something we've learned over time here. Okay, if you have customers contacting each other, getting information, personal information of how to contact each other, probably want to put some terms of use in there about bad conduct, because some people are going to start stalking people. Some people don't want to be contacted, things like that. So definitely put that on there too. And of course, saying you can kick anybody off if they engage in the bad contact there. When we have buying stuff, this is important to say, okay, yeah, if you want to go through the whole process of essentially setting up your own PayPal and accepting credit cards from everywhere and stuff like that, be my guest, but generally most sites will use a third-party payment processor like Stripe or PayPal or Plaid or something. And the reason for that is that, especially if you're doing transactions over state lines, PayPal, Stripe, Plaid, others have already figured out what the laws are with processing payments over state lines. So if you try and pick it up yourself, it's going to be kind of, hit and miss, probably mostly miss. And then of course, in your terms of use, you definitely want to have something in there about that you aren't responsible for the third party that is links that you put on your terms of use there. Yeah, you're not responsible for Stripe if they screw something up with a payment or something. Just make sure that's in your terms of use there. Okay, just a few other terms here. Okay, we would also suggest that you put in there something about the website being only for personal use. I mean, if you're selling cowboy boots, for example, you don't want somebody to just mine your cowboy boots, mark them up, and then put their own website up with slightly higher priced cowboy boots and blow you out of the water. No, you don't want to do that. People are just supposed to buy cowboy boots from you because they're going to use them themselves. By the way, I will say that, tell you this little story. We did have somebody coming to our office hours, and they said, well, I've got this new way, this new reliable way to get the best price on a used car. Okay. And we said, oh, that's great. Well, and how do you find that out? And he said, well, what we do is we mine Carfax. We take all the car information of Carfax, and then we use that through with our little algorithm, and we find the best price that they could probably get for that. And then, of course, we asked, well, okay, did you talk to Carfax about using their site this way? And he said, oh, well, they don't really mind, right? I mean, why would they mind in this situation here? So we did encourage him. He reluctantly sent a letter to Carfax to say, this is okay if I do this, right? And they came back, jumped on his head immediately and said, you absolutely positively cannot be using this way. And if we had discovered this, we would have sued you. However, since you came to us in good faith, we have a proposition for you. And they said, your use of the website material here, what about your customers using it? We don't mind if you send your customers to our site and have them get the information and then bring it back to you. That produces more, business for us. And so a relationship, a strategic alliance was formed in that situation there. But yeah, if he had just gone forward and said, oh, I can scrape anybody and get whatever I need to sell, you're waiting for a lawsuit there. As soon as they find it, they're definitely going to come after you. And if you've earned some money from it, they'll go after the money that you earned. So, all right, here's a few other things to put on your terms of use. Definitely the website terms can be changed anytime without notice. You don't have to inform people. And anytime they come on the website, this next one, you have to have language in there that says user agrees to all changes, that are basically, as soon as you come onto the website, you've agreed to the new terms that we just added there or something. Okay, now here's an important part for marketing and other things. I want to make sure I threw this one in. You definitely want on your terms of use that if you have taken customer information, and we're going to talk about privacy policy in a minute about how you handle that information, but you want to have some limited liability language in your terms of use that say, look, I'm storing this information in a cloud server of some sort. If one of those servers is breached, that happens every day, then I'm not responsible. It's the cloud storager's responsibility going forward, you see. Okay, so definitely have that in your terms of use as well. All right. And as I said, terms of use are made enforceable by either prominent display on your website or that click saying I do agree, or something like that. All right, well, we're in the final stretch here. What about privacy law? Oh, okay, by the way, those are cookies, which is, yeah, part of you agree to the cookies. And remember, the cookie is the address of your computer that then is interfaced with the computer of the website that is the server. And so when you come back to it, it already identifies you from some of these, the data or the code that was transferred the first time. And that's where you agreed to transfer that little bit of data that's called a cookie. Okay. All right. Well, anyway, you should know that California on privacy laws is very cutting edge in the country here. They passed the first law in the US to establish this protection for the handling of consumer data gathered over the web. It mirrors Europe's tough standards that are called GDPR. And so it's something you're going to have to pay attention to if you're operating in California or have a seller in California or things like that. So it requires first that you have on your website a privacy policy, linked to your homepage. So it should say up at the top, terms of use and privacy policy. And generally it applies to any commercial website that collects or maintains personally identifiable information, or called PII, from users residing in California. So let's talk a little bit at this last slide here about privacy policy, which you should be doing, okay? As I said, privacy policy that you would have on your website is designed to protect the personally identifying information. That's either a person's name or address or phone, or even the address of their computer that they don't even know what the address is. So, wait a minute, come back. Where did we go? Sorry, here we go. So the California Consumer Privacy Act, which is the source of this law here, you should know that right now it applies primarily to large businesses, so 25 million plus. But these other places they could apply could possibly apply to you. You are gathering more than 50,000, people's data. or you're deriving at least 50% of your revenues from selling the data. Okay, if that's the case, then you got to do a number of things. It reflects those national trends. Okay, but here are some of the things you have to do. I've pulled out the sort of most important ones. You need to explain in your privacy policy how PII is collected and shared. You need to have a process where users could ask you for a copy of all the information you got from them, and you have to allow them to request to delete it, and you have to delete it if they ask it. So they have to have an easy opt-out, but also from sharing. Maybe they didn't say you have to delete the data, but we don't want it shared with somebody else. It's got to be an easy opt-out at the bottom of your website or any communication you have with them. Click here and unsubscribe or something like that with no consequences. You're not going to ding them on their price or something like that because of that. And then really important thing is any data you're gathering from minors, that is 13 years old or under, cannot do that without parental consent. Okay, so that's what's called the Children's Online Privacy Protection Act. That's a federal act that makes that bite. Okay. All right, well, I think those are the main things. As I said, privacy policy terms of use, we have sample ones that you can use. I guess what I'd say is we can go to some questions now. But this is the sign up where you go to the website to sign up for services. That's where you get the office hours. Oops, sorry. We also have this online legal library for entrepreneurs that you can check out. It's called OLLI. Online legal libraries for entrepreneurs. OLLIlegal.com, you can see a bunch of other sort of lay-friendly legal information that can answer probably a bunch of questions that you might have. That was assembled by our attorneys and by our students as well. So, okay, hey, well, let's take some questions here. Hey, Lena, I just have one quick thing, and that is it looks like our office hour client is going to start in about 3 minutes. I'm just wondering, maybe, Lena, if you could go and get on that meeting right away so that then if we spill over a little bit, you'll be able to start and just talk a little bit before we get there. Is that okay? Good. Okay, thanks. All right, so some questions. Let's get to it. Let's see what the chat said here. Oh, I don't see any questions. Okay, well, folks, go ahead and unmute yourself and we'll take some questions. Anybody? Well, I guess what I would say is if you do have some follow-up questions, of course, sign up for the office hours. And if anybody does want to get any of those sample things that we have, so that would be terms of use and privacy policies. Those are the main things, I guess we would, but the most relevant things. So if you like that, go ahead and put your address in the chat. Now, one thing I would say about terms of use and privacy policy is that you can actually go, if you don't have those things yet, you could go to a competitor's website, somebody who does something like what you do, okay, and take theirs. And the reason is that one of the exceptions to copyright is legal language, because nobody should own certain legal language that's the best legal language going around. Okay, so it's not like a judge is going to come back and say, wait, you took that from Airbnb, you can't do that. So, but the only thing you got to do, you got to make sure you do this, is you take that terms of use or privacy policy from another website, just make sure you go through it with a fine comb and take out all of the identifying information company and put in your own. So I think I've seen before people taking like Airbnb, terms of use, and they try and apply it to their like food business. And then all of a sudden there's language in there about, well, if you have a problem with the apartment, when you get in it, well, you call this to get troubleshooting. Well, that won't apply to your bakery, but also don't have that in there, because obviously it looks like you took it from Airbnb and it's not going to be functional. So anyway, just make sure that you scrub it well and make it your own, and make sure it has the functionality that you need for your particular website. Yeah. Okay, well, it was really nice meeting with you folks. Do let us know. We'll be back next month. I think we've got a whole, there you go. We got a list of different things. We're going to do hiring next month. We're going to do capital, demystifying contracts. Oh, by the way, Sandra, we did a new workshop this past week that we should add to the list. It's called the Legal Checklist for Consultants. So this would be anybody doing a business where you're consulting with other people. It would include things like caterers, of course, you're consulting about food, but also things like you're an engineer and you're consulting about, structural issues, or, you're consulting with, you're a birth coach, you're consulting on the best way to give birth or something like that. Any of these kinds of professions where you're giving out advice based on your expertise, certain issues there. So maybe we'll add that to the end of this list of series here, if that would be helpful.
Yeah, I like that. And like you mentioned, these workshops, they're provided every third Friday of the month. So as Bill mentioned, our next topic would be October 15 on the topic of hiring workers. And I really like that legal checklist for consultants, especially nowadays we're becoming self-employed, is becoming more, there's more opportunities and more laws protecting the self-employed individuals. So I think maybe for December, we can swap that current topic for the legal checklist for consultants. So I like that idea.
Good. Okay, well, thanks for having us, and we'll be back. And thanks, Sandra, for being so welcoming to us. We just want to get that free legal help out there for entrepreneurs. So.
Absolutely. So, and of course, as always, this webinar will be posted on our YouTube account and will be shared with all participants, in addition to those terms of use and privacy policy. So thank you so much, Bill. Thank you, the team at Linguistica, for today's translation. And thank you, each one of you, for joining us today.
Thanks for the translation. Oh, Sandra, so I will be sending you